Hello and welcome to Fast Fact Friday, brought to you by the Community Environmental Legal Defense Fund and their non-legal advice giving communications team. Today we're breaking down state interference with local democracy. Hold on, that's wrong. Let me check my notes. Preemption. We're talking about preemption. Fantastic. Now, there's a whole lot to talk about with this one, and it even comes with a legal warning. So hold on to your seats, humans of Earth. This one is a page turner. Let's start with the basic definition. The preemption doctrine is the idea that a higher authority of law will displace the law of a lower authority when the two authorities come into conflict. In the U.S., this doctrine usually means that federal law trumps state law, which both then trump local law thanks to the Supremacy Clause. Preemption is often argued to be a neutral doctrine, but increasingly lawmakers in states within the U.S. are proposing and enacting laws and ordinances that would, in effect, remove power from local communities to protect themselves. In reality, every community is different. Population, economic conditions, demographics, all of these differences mean that the policies that may work best for one community just doesn't make sense for another. That is why local government exists. It was created to accurately reflect the unique views and values of the people who live there. Let's break it down just a little bit more. There are two main types of preemption: express and implied. Express preemption occurs when a federal law expressly states that it is intended to preempt state and local law. State laws can preempt local laws too. Let's look at Ohio. In 2019, the Ohio budget incorporated a section that reads, "Nature or any ecosystem does not have standing, and no person on behalf of or representing nature or an ecosystem shall bring an action in any court of common pleas." Those two sentences obstructed several local initiatives that were on the path to qualify for county ballots or had already been voted on and approved by residents. Implied preemption occurs when a court decides that even though the federal law doesn't explicitly state it preempts state law, it nevertheless does. For example, if a state law required all widgets to be read and a federal law stated that no widget could be read, the state law would be preempted because it is impossible to comply with both laws and still make those adorable little widgets. Industry lobbyists have successfully pushed state lawmakers across the country to put their interests and profits ahead of allowing local governments to support a clean environment, local democracy, and safer communities. We see an increase in states passing preemptive laws across the country. In 2009, Virginia had preempted local governments from passing laws impacting some of the most basic aspects of local life. Virginia's issues fall under things called floor and ceiling preemption. Floor preemption is where the federal government or state government sets a minimum level of protection below which states or local governments cannot go, like federal minimum wage. Ceiling preemption, on the other hand, is where the federal or state government sets a cap on how much state or local governments can protect people's rights, health, and welfare. Even the Center for Disease Control has identified ceiling preemption as a barrier to public health laws. States have historically set their protective laws as minimums, and cities have been able to localize and, when necessary, build and strengthen those laws. Ceiling preemption has no legitimate function in a system of law where government is supposed to protect its residents. When preemption is used by corporations as a tool to take away power from local democracy and to diminish local power and decision-making, we all lose. For more information on state interference and preemption, head over to celdef.org. Thanks for tuning in, and a special shout out to all the lawyers who looked this one over for us, but then told us we had to say, "This is for information only and shouldn't be taken as legal advice." We appreciate y'all.